Hello everybody, welcome back to the channel. Hopefully you guys are all caught up on the 14 videos that I made for you on business trust from American Jurisprudence, volume 13. To continue, it will be beneficial, otherwise you might get lost in the upcoming videos that I'm going to be making. Also, on my Telegram group, I will have been offering, for anyone who's interested, is a trust class from beginning to end, even on creating a trust. I was thinking somewhere between 6 to 8 weeks, twice a week, 3 to 4 hour periods. And that will be dependent on what book that I will be utilizing. But also the question remains too that there's actually two topics of trust that need to be understood. And that's business trust and ordinary trust. So it's like the class is going to be one or the other or both. So, and both I think would be a lot better because you'll be able to compare and contrast what the original principles of trust are and its connection to a business version of the same concept. But yeah, I'm just looking see if anyone's interested in that or on some specific topics on management of a trust, which I got several books from sources of income to U.S. taxation of foreign estates, trust, and beneficiaries. So just let me know. Today will be a continuation on trust law, but this will be a court case. Some of you might have heard of this case. I know Yusavell has made a video of this, but I believe the video was in private, right? So this is Evans versus Newton, 382 U.S. 296 in 1966. And this case is a trust law case that will show you at least a line for what is considered public and private, right? It should show you all this is just a hat that you wear. What else? What else is going to show? A little bit on the charitable trust stuff, right? Because that's ultimately what he's creating. Well, we'll see. There's several things. I'm going to point them out as we go. It's a good size. It's a good size court case, so it'll be about 45 minutes, give or take. All right, so this is about a senator. I believe he was a senator that created a trust, a park, for public consumption. But his public was for whites only, right? So argued 1965, decided 1966, and they sent it up to the Supreme Court, certiorari, right? Let the record be brought. A tract of land willed, so this is a will, in trust to the mayor and city council of Macon, Georgia, as a park for white people to be controlled by white board members. When the city ultimately desegregated the park, the individual managers brought this suit to the state court against the city and the trustees of residuary. It's the remaindermen, residuary beneficiaries. And as for the city's removal as trustee and the appointment of private trustees to enforce the racial limitations of the will. So the beneficiaries, right? This residual beneficiaries, whatever that term means, right? I want to say remaindermen, right? They complained and wrote and filed with the state to continue the racial limit segregation of the park because that's what the trust called for. The city, which had alleged that it could not legally enforce segregation, asked to resign as trustee after intervention of Negro citizens who claimed that the racial limitations violated the law. So people stepped up and complained that this shit's a public park. What are you doing? You can't violate the Constitution. Other heirs of the testator who had also intervened asked, along with the individual defendants, for reversion of the property if the prayer of the petition was denied. The Georgia court, without passing on the heirs' others' claim, accepted the city's resignation as trustee and appointed 3 new trustees. The Negro interveners appealed. The Georgia Supreme Court affirmed, holding that the testator had a right to leave his property to a limited class and that charitable trusts are subject to the supervision of an equity court, which could appoint new trustees to avoid failure of the trust, which is a true thing, right? The court held 1, where private individuals or groups exercise powers or carry on functions governmental in nature. So private individuals or groups exercising powers or carrying on functions that are governmental in nature. They become agencies or instrumentalities of the state and subject to the 14th Amendment. Where the tradition of municipal control and maintenance has been perpetuated for many years, proof of the substitution of trustees is not enough, insufficient per se to divest the park of its public character, meaning these powers that you are utilized that have the function of a government, right, or characteristic, right, and substituting the trustees was not enough to remove that characteristic, that public character. Why? Because it was under municipal control and maintenance by the public, and still was after the trustees were replaced. The services rendered by a park are municipal in nature, and under the circumstances of this case, the park is subject to equal protection requirements of the 14th Amendment, and they reversed the case, right? So the lower courts, they were all for it to keep it segregated and all that stuff, but this court is breaking it down completely. That's why so many things get flipped. These lower courts are acting always in an administrative capacity. They don't got the Constitution in mind. In 1911, the United States Senator Augustus O. Bacon executed a will that devised to the mayor and council of the city of Macon, Georgia, to a tract of land which, after the death of the senator's wife and daughter, so this is his will, but this is after the death of wife and daughter, was to be used as a park and pleasure ground for white people only. The senator stating in the will that while he had the kindest feeling for the Negroes, he was of the opinion that in their social relations, the two races should be forever separate. The will provided that the park should be under the control of a board of managers of 7 persons, all of whom were to be white. The city kept the park segregated for some years, but in time let Negroes use it, taking the position that the park was a public facility which it could not constitutionally manage and maintain on a segregated basis, which is absolutely true. So think about what this guy created. Now, this is a senator, a public figure, created a private trust and appointed public trustees. Now, the thing is this. He still created a private trust. meaning that the hat that he's wearing here, right, even though he's a senator, he really created in his individual and private capacity. He didn't create this from his powers and property as a senator, because that's public. That anything that he is under his control as a senator, that's public. But nonetheless, what I want to point out here is regardless of his status and his job, right? He had the ability, because all of this is a hat, he still had the ability to write a contract in his private capacity. That's all I'm saying. The will provided that the park should be under the control of the board of managers of 7 persons, all alike. The city kept the park segregated. I already read this. All right, so thereupon, individual members of the board of managers of the park brought this suit to a state court. So this is the managers suing themselves, or at least attacking, right? Which trustees can do, right, or whatever. Especially if they want clarification, right? Because you can always ask in a court of chancery for an interpretation for your trust. If in the future, like this case here, right, he died, and his family lived on, his daughter lived on probably, the 20, 30 years. There's no one around for interpretation of who probably originally wrote the trust. So it's like, man, if you can't understand it and there's a debate or some argument between you and some beneficiaries or you and creditors, man, dude, interpretation is what's going to be needed. For you to protect yourself as trustee, interpretation is going to be needed. All right, so the individual members of the board of managers of the park brought this suit in a state court against the city of Macon and the trustees of certain residuary beneficiaries of Senator Bacon's estate, asking that the city be removed as trustee and that the court appoint new trustees to whom title to the park would be transferred. The city answered, alleging it would not legally enforce racial segregation in the park. The other defendants admitted the allegation and requested that the city be removed. So this is agreement here. You know how agree with your adversary? Okay, well, this is like one aspect of it. One of them said something on the racial segregation, and then the other party agreed with them. Yeah, you can't do that. Several Negro citizens of Macon intervened, alleging that the racial limitation was contrary to the laws of public policy of the United States, and asking that the court refuse to appoint private trustees. Thereafter, the city resigned as trustee and amended its answer accordingly. Moreover, other heirs of Senator Bacon intervened, and they and the defendants, other than the city, asked for reversion of the trust property to the Bacon estate in the event that the prayer of the petition were denied. The Georgia court accepted the resignation of the city as trustee and appointed 3 individuals as new trustees, finding it unnecessary to pass on the other claims of the heirs. On appeal by the interveners, the Supreme Court of Georgia affirmed, holding that Senator Bacon had the right to give and bequeath his property to a limited class. So they're stating that he had the right to give his property specifically to white people all day long. And there's groups, organizations you know of that are famous and others that you don't. They do it all the time. That charitable trusts are subject to supervision of a court of equity, and that the power to appoint new trustees so that the purpose of the trust would not fail was clear. The case is here on a writ of certiorari. So what do they mean here? Charitable trusts are subject to supervision of the court of equity. Well, what's the definition of a charitable trust? Its purpose is towards a group of people, but the people is considered for a public purpose. So it's like this right here is automatically under the supervision for them. So if you're thinking of like now look at this in terms of an aspect of what's considered a foreign trust, right? Under 7701, what is that, 30E or something? Well, this right here automatically passes the control test, the court test. A charitable trust always will pass the court test. No matter what jurisdiction that you're in. Now, does it pass the other test, the control test? That's different. Because you need both to be a U.S. person. There are two complementary principles to be reconciled in this case. One is the right of the individual to pick his own associates so as to express his preferences and dislikes, and to fashion his private life by joining such clubs and groups as he chooses. The other is the constitutional ban in the Equal Protection Clause of the 14th Amendment against state-sponsored racial inequality. So understand, the Constitution and the restrictions apply to government. So if the 14th Amendment bans them from being discrimination against race, it applies to them. You, at any time, could create a group specifically for like-minded people, and that's it. Like, it doesn't matter what the subject is that you guys want to discuss. It's your right to do so. Which, of course, bars the city from acting as trustee under a private will that serves the racial segregation cause. I'll give you a case there. A private golf club, so this is a court case, I think. Right. A private golf club, however, restricted to either Negro or white membership, is one expression of freedom of association. But a municipal golf course that serves only one race is state activity. So a municipal golf course that serves only one race is state activity, meaning he is an instrumentality of the state, indicating a preference on a matter as to which the state must be neutral. Now think about why businesses that are open to the public cannot discriminate on certain things. They'll get sued on certain things because they're open to the public. It's not private. You got an open sign on your door. You are open to the public. But in a private golf club, you can restrict whoever you want. What is private? What is private action and what is state action is not always easy to determine. Conduct that is formerly private may become so entwined with governmental policies or so impregnated with a governmental character as to become subject to the constitutional limitations placed upon state action. Apply this to your life as an individual. What things are you doing that are so entwined that have a national, in most cases, right, a national governmental character? The action of a city is serving as trustee of property under a private will, serving the segregated cause is an obvious example. A town may be privately owned. What did they just say? A town may be privately owned and managed, but that does not necessarily allow the company to treat it as if they were wholly in the private sector. Thus, we held in Marsh versus Alabama that the exercise of constitutionally protected rights on the public streets of a company town could not be denied by the owner. A state is not justified, we said, in permitting a corporation to govern a community of citizens so as to restrict their fundamental liberties, which should be a given, right? Private or public, no one should be denying and screwing with your fundamental rights. Outside, of whatever it is that you limited yourself by being in the community that you're in, whether that's a municipality, right, a public one, or a private one, because as well as I do, there are public communities out there that have signed on into contracts to obey certain things within those borders. That's private. Now, those things that they sign can be restrictions on what? Their fundamental liberties. They accepted this. This is the whole aspect of contract law. Rights are taken and rights are given. Says a state is not justified, we said, in permitting a corporation to govern a community of citizens so as to restrict their fundamental liberties. We have also held that where a state delegates an aspect of an elective process to private groups, they become subject to the same restraints as the state. And that's, the elective process, the only thing I can think of, that's one of the powers, right? Or elective process would be the ministerial duty of the power that they received through the Constitution. Like what they're doing now with some private groups. That is to say, when private individuals or groups are endowed by the state with powers or functions governmental in nature, they become agencies or instrumentalities of the state and subject to its constitutional limitations. Yet generalizations do not decide concrete cases, only by sifting facts and weighing circumstances. We can determine whether the reach of the 14th Amendment extends to a particular case. The range of government activities is broad and varied, and the fact that government has engaged in a particular activity does not necessarily mean that an individual entrepreneur or manager of the same kind of undertaking suffers the same constitutional inhibitions. So he's saying right here that just because the government is in the business of whatever that is that you're doing in your private life doesn't mean that the restrictions imposed on them applies to you. While a state may not segregate public schools so as to exclude one or more religious groups, those sects may maintain their own patriarchal educational system. Pierce versus Society of Sisters. If a testator wanted to leave a school or center for the use of one race only, and in no way implicated the state in the supervision, control, or management of the facility, we assume arguendo, and that no constitutional difficulty would be encountered. What do you think this means? In arguing, or for the sake of argument. Assuming this is the legal definition to it. It is used in court opinions when a judge wants to express that a statement is true for the purpose of argument, even if it is not true or they do not believe it is true. Oh, so it's for the purpose of argument, right? Let's say it's true. Not to say it's not or is, but let's just create an argument, right? You're creating a fiction right there, if you guys understand what I mean by that. That, because this is a term that we've heard all our lives, right? Just let's say it's true. And then come up with a scenario that's going to play out if it's true. And then, okay, let's say if it's false, let's play out this scenario. But they're saying that no constitutional difficulty was encountered. So their scenario states that there's no constitutional violation here. Nothing's being done here. It's a private, the testator, right, in this case would be a private organization that does not have the state involved in any way. This park, however, is in a different posture. For years, it was an integral part of the city of Macron's activities. From the pleadings, we assume it was swept, manicured, watered, patrolled, and maintained by the city as a public facility for whites only, as well as granted tax exemption under Georgia Code. The momentum it acquired as a public facility is certainly not dissipated ipso facto by the appointment of private trustees. What did they just say? That its public characteristic does not go away just because you got private trustees. And in this sense, it has nothing to do with activities. It has everything to do that this public park or whatever, right, that's being transferred back into the private still is being funded by the public. So far as this record shows, there have been no change in municipal... what did I just do? So far as the record shows, there have been no change in municipal maintenance and concern over this facility. Whether these public characteristics will, in time, be dissipated is wholly conjectural. Why? Because it's completely dependent if the new trustees are going to take over that business, right? Those ministerial duties of taking care of it, cleaning it, watering it, blah, blah, blah. Are they going to take care of all the things that we were paying for? That's what that means. Where'd it go? Yeah. Where these public characteristics will, in time, be dissipated is wholly conjectural. If the municipality remains entwined in the management or control of the park, it remains subject to the restraints of the 14th Amendment, just as the private utility in Public Utilities Com and Polak. So they're saying this is an example that this private organization was so entwined with public aspects that it became a public utilities. It was subject to the 14th Amendment. This is how they get in your house. Things like this right here. How the people, we all know that it's a restriction on government. But now if you are acting in a role, an activity that is regarded as public, right? Meaning it's the government has control. Well, then you're one of them. just because, it's like putting on sheep's clothing and saying, hey, I'm here. I'm not one of you guys or something, but you're in their house. So private utility and Public Utilities Com versus Polak remains subject to the Fifth Amendment because of the surveillance which federal agencies had over its affairs. We only hold that where the tradition of municipal control had become firmly established, we cannot take judicial notice that the mere substitution of trustees instantly transferred this park from the public to the private sector. And look at it like this too, about your home. If you have a mortgage, what is it that's happening here that is being back protected or whatever funded by the government? What benefit is this property receiving? And what characteristic does that give it? It's not yours. It's not private, that's for sure. This conclusion is buttressed by the nature of the service rendered the community by a park. The service rendered by even by a private park of this character, is municipal in nature. It is open to every white person, there being no selective element other than race. Golf clubs, social centers, luncheon clubs, schools such as Tuskegee was at least an origin, and other like organizations in the private sector are often racially oriented. It's common. That's what he's saying. It's common. Everyone was doing it. It wasn't just whites. A park, on the other hand, is more like a fire department or police department that traditionally serves the community. Mass recreation through the use of parks is plainly in the public domain. Watson versus Memphis. The state courts that aid private parties to perform that public function on a segregated basis implicate the state in conduct proscribed by the 14th Amendment. Like the streets of the company town in Marsh versus Alabama, the elective process of Terry versus Adams, and the transit system of public utilities, the predominant character and purpose of this park are municipal. And this is right here, dude. Like, if you want to continue your research, right here, these three cases on this topic specifically, and it'll be a private versus public aspect, topic. Under the circumstances of this case, we cannot but conclude that the public character of this park requires that it be treated as a park institution subject to the command of the 14th Amendment, regardless of who now has title under the state law. We may fairly assume that had the Georgia courts been of the view that even in private hands, the park may not be operated for the public on a segregated basis, the resignation would not have been approved, the private trustees appointed. But we put the matter that way because on this record, we cannot say that the transfer of title per se disentangled the park from segregation under the municipal regime that long controlled it. There's a follow-up to this case. I think it's like 3 years later, like in 1969 or something, that finally they got the park back, like the family did. Like, because, there's multiple parties here. You have the board of trustees that filed the complaint. You have the interveners that were hurt by not being able to use the park. And then you have the family or whatever else that were butthurt that the principles of the trust cannot be upheld, right? So they got their back. So the third party, they got it back. I don't know the citation to that. I should find that because that might be. They don't go through that. I remember reading it, but they don't go through the whole case. They go through, the new stuff of them showing that, hey, we're not of a public character no more. All the things that used to make us public are not there no more, are not present. Let me see if I should read anything else. How come they got the footnotes here? Since the judgment below gives effect to that purpose, it must be and is. Was I reading the syllabus or something? And is accepting the resignation of a trustee and appointing successor trustees. The lower court judgment does not enjoin the new trustees to comply with the racial restriction in the trust, and there is therefore not presented for decision the question whether, should the trustees fail to exclude Negroes from the park, state judicial enforcement of the judicial restriction would constitute discriminatory state action forbidden by the Equal Protection Clause of the 14th Amendment. But we do have properly before us, in my opinion, the question of whether the 14th Amendment prohibits the new trustees from voluntarily excluding Negroes. This is so because decision of the state law questions in this case was not independent of that federal question. The city's resignation, its acceptance by the state courts, and the appointment of new trustees were all based on the premise that the city could not, but private trustees could, obey the racial restriction in the trust without violation of the federal constitution. And you know what's another thing too? You know the concept, especially like what's going on with with the suppression and restrictions and straight up cancel culture that they have right now, right? Well, the court case is going on with that, right? With the administration that's in play now. They straight up violated the Constitution, like on all levels. Like I'm talking about all the agencies, the multiple various fucking different congressmen and senators. Dude, like every single thing they did is 100% violation of the Constitution. If not, the term, man, what court case was that? The term is warring against the Constitution. That's what they did. And that, I believe that case was a case on treason. But man, that's what they did right there. And like this, that's what this is doing right here. That's what this shows, right? Like a private person cannot do something that the government couldn't do in the first place. So like they have public trustees, fine, okay, but they have restrictions upon them. Okay, well, they still want to do the way the contract says, the trust, right? So they're trying to get private parties to do it for them instead. Oh, well, if you didn't have the power in the first place, you can't do it, you know what I'm saying, as a private party either. But that, although this case is not like specific like that, because the tie, right, the minimum contact was all the benefits they were receiving. Right? So that's the minimum contact was the benefits that the trust, the park was receiving. But it's to understand the greater complexity of what's being discussed right here is like, man, it's huge to understand the line of public and private and how easily they could get in your house, your business, and all that stuff. You got to understand what private business is. Well, now, it's probably easier to understand where the line is at. When is it that you are in the public? That's what I think. If that premise was incorrect, this court should vacate the judgment below and remand for further consideration of the state laws issued free from the compulsion of an erroneous view of federal law. That the 14th Amendment prohibits operation of the park on a segregated basis so long as the city is trustee is, of course, not disputed. See cases cited. Whether the successor trustees may themselves operate the park on a segregated basis is the question. The majority holds that they may not. I agree, but for different reasons. To a large extent, the majority grounds is its conclusion that exclusion of Negroes from the park after the change in trustees would be state action and thus violative of the 14th Amendment on the existence of prior municipal involvement in the operation of the park. The momentum acquired as a public facility. Momentum, they're calling the park momentum. I didn't catch that last time. Or I think I read it on a case text. The momentum acquired as a public facility is certainly not dissipated ipso facto by the appointment of private trustees. So far as this record shows, there has been no change in municipal maintenance and concern over this facility. Whether these public characteristics will, in time, be dissipated is wholly conjectural. We only hold that where the tradition of municipal control had become firmly established, we cannot take judicial notice that the mere substitution of trustees are. So this is what he was saying earlier. It is equal evident that the record does not show continued involvement of the city in the operation of the park. The record is silent on this point. So that means there's no evidence that for whatever period they're talking about. It is equally evident that the record does not show continued involvement of the city in the operation of the park, which should be a good thing to get your park back. On the contrary, the city's interest would seem to lead it to cut all ties with the operation of the park. It must be as clear as the city as to a court. It must be as clear to the city as to this court that if the city remains entwined in the management or control of the park, it remains subject to the restraints of the 14th Amendment. And should segregation in the park be barred, the residuary beneficiaries would undoubtedly press their claim that failure of the trust purpose expressed in the racial restriction results in reversion of the park property. So failure to accomplish the purpose of the trust triggers a reversionary provision in the trust. It seems unlikely that the city would act so as unnecessarily to jeopardize the continued existence of this centrally located park, which comprises about 100 acres and is one of the city's largest park. I would like to know what park this is. I don't recall that they stated anywhere here. You're talking about that's 100 acres, and then you're talking about in the middle. I mean, whoever's in Georgia, Macon, right? 100 acres. Centrally located park. So they give an address. That the city's own interest might lead it to excreate itself at once from operation of the park does not, of course, necessarily mean that it has done so. And I am no more inclined than the majority to resolve this question by conjecture. I refer to possible inferences from the city's self-interest solely to emphasize that the record affords absolutely no basis for inferring continued involvement of the city in the management and control of the park. What the majority has done is to raise a presumption of one fact by showing the absence of proof of the converse. To postulate in this manner that the city's involvement has not been dissipated is simply to disguise form of conjecture, and I submit is a insufficient basis for this. He just attacked his colleagues on their way of thinking, and the other justices, and told them why they're wrong. I would nevertheless hold that the racial condition in the trust may not be given effect by the new trustees because, in my view, it is incurably tainted by discriminatory state legislation validating such a condition under state law. The state legislation to which I refer, these sections of under the Georgia Code, which were adopted in 1905, just 6 years before Senator Bacon's will was executed. So 6 years before he died. These sections make lawful charitable trust dedicated in perpetuity to the public use as a park, pleasure ground, or for other public purposes, and provide that the use of said park, pleasure ground, or other property so conveyed to said municipality may be limited to the white race only, or to white women and children only, or to the colored race only, or to colored women and children only, or to any other race, or to the women and children of any other race only. That's the provision. This is the provision in the trust. No. No, this is the provision in the thing. Yep. Gifts for public parks and pleasure grounds. So this is the statutes. Municipally organized, authorized to accept property. You know what though? This is not okay. So the senator, he used this statute, but this statute did not create the trust. Right? Because I was thinking like, well, he used the statute to create the trust. That means it's not really private. Okay, well this doesn't create the trust. He created the trust and used this statute for the municipality to accept his gift for whatever purposes, whatever, you know. At first I was like, what? He accepted, he used a statute. As this legislation does not compel a trust settlor to condition his grant upon use only by racially designated class, the state cannot be said to have directly coerced private discrimination. Nevertheless, if the validity of the racial condition in Senator Bacon's trust would have been in doubt but for the 1905 statute, and if the statute removes such doubt only for racial restrictions, leaving the validity of non-racial restrictions still in question, the absence of coercive language in the legislation would not prevent application of the 14th Amendment. For such statute would depart from a policy of strict neutrality in matters of private discrimination by enlisting the state's assistance only in aid of racial discrimination, and would so involve the state in the private choice as to convert the infected private discrimination into state action subject to the 14th Amendment. And you know what's crazy? Everything that people are out there doing with this racial or reverse discrimination that they're doing, dude, they're all liable to the 14th Amendment to be sued. If they are using a platform that is being funded by the government, absolutely they can be sued. This is why every single, well, not every single yet, you're right, but, you know, nurses, police, firemen, military, I don't know about military, but, dude, they all have been winning their lawsuits from the 2020 crap that was been going on and why they lost their jobs. The government had no authority to do that shit. Now, if there wasn't some, let's say, for lack of a better word, awakening for us, for people in general, right? And where we got our help in our education of what's really going on out there, dude, like all those violations would still be going like nothing and no one would know nothing. At least we're being aware of it now because people are paying notice and willing to sacrifice whatever it is they're willing to sacrifice to promote truthful information. But this shit crazy. Although there are no Georgia decisions directly on the point, and the question is therefore not free from doubt, the available authorities have led me to conclude that these sections did not involve the state in the private choice by favoring racial discrimination over private discrimination based on grounds other than race. So he's just saying that the statute did not force the senator to pick, right? So they're trying to say that it's still constitutional because it was the choice of the creator or the gifter, right? The trust. Apart from these statutes, the Georgia statute governing the determination of permissible objects of charitable trust, this statute almost copies the statute of the 43rd Elizabeth. Newsom versus Stark, 1872, and has the effect of fully operating in Georgia the common law of charities. Jones versus Habersham. That's probably something you guys, whoever's into charities right here. Especially, you read this, right, is in the hopes that they give you either another court case or some type of book, right? Where, because back then, more often, along with court cases, they would cite authors, right, that are well known and respected in the authority of whatever subject that they are writing about. So it's like, man, for old cases, I try to look for those because then I want those books. Because then you could follow those books just like you could do with court cases with shepherdizing and stuff. But, I'm a book guy, so. We may therefore expect general charitable trust principles to be as fully applicable in Georgia as elsewhere in the several states. Under such principles, there is grave doubt concerning whether a charitable trust for a park could be limited to the use of less than the whole public. In the leading case, Commissioners for Special Purposes of Income Tax versus Pemsel, 1891, Lord Mactagen established a classification of charitable trust that, with some modifications, has since prevailed. Charity, in its legal sense, comprises four principal divisions: trust for the relief of poverty, trust for advancement of education, trust for advancement of religion, and trust for other purposes beneficial to the community, not falling under any of the preceding heads. See also Restatement, the second edition. Trust, a more general test of what a charitable is, whether the accomplishment of the trust purpose is of social interest to the community as to justify permitting property to be devoted in the purpose of perpetuity. Scott on trust. The first three categories identified by Lord Macnaghten designate trust purpose that they have long been recognized as beneficial to the community as a whole, whether or not immediate benefits is restricted to the relatively small group, and that therefore satisfy the general test stated by Professor Scott, 1959. I wouldn't mind having that book. Actually, there's a 1931 Scott. It's Austin Wakeman Scott. That's the guy. You are not. It's hard to find his books in PDF format or in any other place that you're not buying, right? Like, out of all my authors, I have two books of his. One is a 3-volume, which someone gave me, right? Island Girl gave me that, and the other volume is I think lectures or court cases or something. I forgot. I haven't really read through it, just skimmed through it, but it was a while ago. That was that. All right, so. But the present trust falls under the fourth category, and can therefore be sustained as charitable only because the generality of user beneficiaries establishes that it is beneficial to the community. Otherwise, a trust to establish a country club for the use of the residents of the wealthiest part of the town would be charitable. So you could establish a charitable trust specifically for a wealth group, as long as they are a good percentage, whatever that percentage might have to be of the overall community, where they are looked at as, for lack of a better word, an association, a group, or some membership of class of persons. You know how you got the Asian village and Hispanic village and whatever else communities. All right, well, that's a class of people grouped together. Well, money does the same thing. Rich people stick together. Where am I at here? Otherwise, a trust to establish a country club would, for the use of the residents of the wealthiest part of town, would be charitable. Scott states this principle as follows. As we have seen, a trust to promote the happiness or well-being of members of the community is charitable, although it is not a trust to relieve property, advance education, promote religion, or protect health. In such a case, however, the trust must be for the benefit of the members of the community generally. So what they say right here says, as we have seen, a trust to promote the happiness or well-being of members of the community is charitable, although it is not a trust to relieve poverty, advance education, promote religion, because trust could be used for any purposes. The charitable trust is the aspect that it's a trust created for the purpose of relieving poverty, education, and so forth. The trust by itself, that's why they wrote that. I'm guessing why they wrote that here. Although it is not a trust to relieve, they're talking about the guy, relieve poverty, advance education, promote religion, or protect health. In such case, however, the trust must be for the benefit of the members of the community generally. Now they're talking about the park. Although it is not a trust to relieve, so they're talking about the park. The trust is not one except for the benefit of the community, which was number 4. I was going to interpret that all wrong right there. Trust for town was charitable. It is public because it relates to all the inhabitants of a particular community, and not to any classification of such inhabitants, or to any group thereof separately from the other inhabitants, by any distinction of race, creed, social rank, wealth, poverty, occupation, or business. From the present case, no Georgia cases dealing with trust for general community purposes have been found. See the validity of charitable gifts in Georgia. So this right here, whoever is in Georgia, I would want to get this if I was living in Georgia. That book, The Validity of Charitable Trust in Georgia. Of course, if you have an interest in charitable trust. But the available Georgia authorities are consistent with the rule enunciated by Scott. Trust to establish home for gentlewomen not charitable. Trust for Negro old folks home is not charitable. Is charitable, sorry. On the whole, therefore, I conclude that prior to 1905 legislation, it would have been extremely doubtful whether these sections authorize a trust for park purposes when a portion of the public was to be excluded from the park. These sections clearly permit exclusion of a portion of the park if such exclusion is on racial grounds. At the same time, those sections appear to make non-racial restrictions on the user of the park created by trust even more doubtful. These sections authorize the conveyance of land dedicated in perpetuity to the public use as a park, and also provides that such conveyance may limit user on racial grounds. The natural construction of this provision would be that it authorizes a trust only for the use of the whole public. So he's saying that the statute, right, the intent of the statute, if and when used, that the purpose has to apply to the whole public. That the statute was being used incorrectly too, right? Or for the use of a racially designated subpart of the public, but not for the use of some other portion of the public, such as men only or Irish persons only. Such an interpretation follows from the maxim expressio unius. Let's look this up. Something that's stated and not stated or something. Principle in statutory construction. When one or more things of a class are expressly mentioned, others of the same class are excluded. When one or more things of a class are expressly mentioned, others of the same class are excluded. But then they have the words includes and including, which are restrictive and expansive. It's expansive only within its own class and restrictive outside of that class. So that's a maxim of law, but like I said, they added other words that changed this maxim or amended to, or at least to that portion. And from the dedication in which the majority refers, which indicate that the expression dedicated in perpetuity to the public use as a park means dedication to the public as a whole and not some portion of the public. So this judge at least attacked it in some way, in a few ways, right? So here you have the attack that it was against the 14th Amendment, that public trustees can't do this, right? Well, because of the reversionary provision of the trust, that since the property cannot be used in the way it was meant to be used, then it goes back to them, back into private hands. But this judge is also saying that the statute that was used should not have ever been restricted to be used racially, because the statute can't apply that in the first place. A statute cannot be used like that in the first place. That it was wrong for the city to do it in the first place, to accept that gift under that premise. You know, the premise in the trust indenture. It's crazy, dude. I'm telling you, case law is where it's at. I don't know what people be thinking, man. Case law is where you have judges are telling you principles of law, man. I don't know how else to say it, man. There can be no dedication, strictly speaking, to private uses, nor even to uses public in their nature, but the enjoyment of which is restricted to a limited part of the public. One commentator has suggested that section was intended to expand Clause 4 of another section to enlarge public works or public conveniences into public parks or pleasure grounds. On that assumption, the whole authority for holding gifts in trust for public purposes to be charitable would be this section, and the section clearly makes non-racial restrictions on use of such parks more doubtful than racial restrictions. Even if this section is regarded as a clarification of prior law rather than an addition to it, it has the same effect of casting doubt on the validity of non-racial restrictions. This case must accordingly be viewed as one where the state was forbidden all private discrimination except racial discrimination. As a result, the state, though through its regulations, has become involved to such a significant extent in bringing about the discriminatory provision in Senator Baker's trust that the racial restriction must be held to reflect state policy and therefore to violate the 14th Amendment. For these reasons stated, I would vacate the judgment of the Georgia court and remand the case for further proceedings. And these are the footnotes. I'm not going to read the dissenting. I'll leave you that up to you. But no doubt, like, That judge right there at the end, it wasn't even that long. His opinion wasn't even that long. 3-4 paragraphs or something. Page and a half. But nonetheless, what did we learn right here? Right? More information to learn about charitable trust. Right? You can find out where that park is at. Find out about the court case that where the reversionary interest, they converted it back into back into private administration. That's probably the proper term to use it. Right? The administration was being executed under private hands, private funds, private whatever. Right? Learned a lot of stuff though. I'm just saying, this is where it's at. Like, there's no other way of putting that. Like, this is where it's at. And I got multiple other cases that I want to read through. But right here, this is clear evidence of public versus private, how they get into your house, how you got yourself into their house, all that. Like, it is what it is. Hopefully you guys enjoyed it. Like and subscribe to the Butterfly Monkey channel. And if you guys are interested in any courses, any classes, or even generally just talking, I usually have the mic open in the afternoons or noontime, right? 1 o'clock, 2 o'clock, 3 o'clock. Well, usually I'll be on the mic instead of talking now. But hope you guys enjoyed. And of course, like and subscribe, and make sure you watch the other videos that I have made to make sure that you will understand as I keep on going. All right. Have a good one, guys.